I feel vindicated. There's a camera right there. I feel vindicated. I told you guys that these are a whole bunch of other lawyers who will remain nameless. I'm not going to name these lawyers, but they were saying this is big conspiracy. And I told you guys from day one, if they got to the house based on the evidence, Nick was going to plead guilty, throw himself on the sword, and say, don't prosecute my wife and girlfriend. And that's what's going to happen. I said that time and time and time again. I said it time and time again. I was called dumb. I was called an idiot. Nate's not a lawyer. Oh, yeah, even though Nate was a prosecutor, he was a cop. He doesn't know what he's talking about. My name was dragged through the mud. But I always said, listen, Nick is going to plead guilty. And in exchange, it's going to save the wife and save the girlfriend. And he's not going to get any jail time. I said that time and time and time again. Nick even called me a dummy. Everybody was on my behind. But today is the day that you understand that sometimes I know what the hell I'm talking about. So now, for those of you who don't know the story, Nicholas Rekieta is a very, very, very good friend of mine. No bones about it. That guy was a friend. I have no bones about it. Nick, I've went on his channel. He's been on this channel. I've met Nick in person. I met his wife in person. So these are not bad people. Let's get back to the document. So Nick has entered his plea to plead guilty to felony charges as long as they let my wife and girlfriend go. I told you the warrant was good. Other people were saying it wasn't. Found out the warrant is good. Told you he was going to plead. He had to plead. He pleaded. It wasn't hard. It wasn't hard. When you're in the business, but when you're in criminal law, you understand criminal law. When you're in civil law, you understand civil law. So I think people need to understand where their lanes are sometimes. Touchdown. The embedded thing was pretty cool too. All right, so here it is. State of Minnesota versus Rekieta. Nicholas Robert Rekieta, defendant in the above entitled action, do respectfully represent and state the follow. Here we go. Where was I at? Okay, I'm Nick Rekieta, blah, blah, blah. My full name, Nicholas Robert Rekieta, 43, date of birth is blah, blah, blah. I had to redact it. That's why it took me a little longer to get here. Last grade, so he's a law school graduate. Case is filed, copy of the indictment. I understand the charges against me are. So now we know, now we're going to see what he's pleading guilty to. Now, I said a guilty plea, they would probably go down to third degree, but he pled to the top count. They can plead to the top count. So we understand I have been charged with second degree violation of Minnesota. That's the 25 grams of coke, possession of a firearm, and child endangerment. Actually, this is what he's charged with. Let's see this may not be what he pleads to, but it seems like that's it. He's represented by this attorney. Do I feel that I have had sufficient? So in other words, this whole section is this is what you've been charged with. This is when it happened. And is your attorney doing all he can to help you out? And he's saying, yeah, all this is yeah, right? And I have never been a patient in a mental hospital. Because if you're a patient in a mental hospital, like, yo, there may be another form you need to fill out. So he had to say, I have never been a patient in a mental hospital. He made a mistake here, though. Like I haven't talked with or been treated by a psychiatrist. So we don't know right now. Has he or has he not? Or other person for nervous or mental condition. So yeah. So here it is. So they're making sure. So what you're seeing here, people, is that they're making sure Nick is mentally able to make this play. So that's what all this is about. I have not been ill recently. I have not recently been taking pills or other medications. That can mean a lot of things. I do not make the claim that I was drunk or under the influence of drugs or medication, and that I did not know what I was doing at the time of the crime. So that's something too. He's saying, hey, I'm full knowledge, full everything, right? I know it all. Nate, the lawyer, do usually change the charges agreed to for a plea and sentencing. They do change it. Like, say, for instance, I can be charged with second degree. That's a good question. I can be charged with like second degree murder, and then I can plead out to like manslaughter. So that's why sometimes they change. I'm assuming this would change too, because his top charge was second degree. So he may have been pled down to like a third degree, to get less time, or maybe to get probation, something like that. But we'll see. We'll see. We're reading the document together because I haven't read this. I haven't read this yet. I just read I went down to the bottom and I was like, oh, and then I skimmed it. So I'm reading it for the first time. So this is just making sure that he's, that he was, he don't make the claim he's acting in self-defense. He wasn't drunk. He don't make the claim that he's been held in jail for so long so they're making sure like, yo, you are pleading guilty because you in fact are guilty. That's essentially what all these questions are getting to. You're pleading guilty because you in fact are guilty, right? It's not because we're holding you down. Thank you, Raven, for the $19. It's not because of anything else. It's because you are in fact guilty. I was represented by an attorney. I had when I had probable cause hearing. So yes, he was, and we saw that. We saw that when he had a probable cause hearing. He made those horrible arguments. They were just bad arguments. But I understand, Nick, is when you're under a gun like that, you make bad arguments because you're nervous, and he's trying to work his case, and it just got bad. But like I kept telling all of you who are interested in this Rekieta thing. There's some of you who probably have never seen this, like, who's this guy? But for those of you who are interested in this Rekieta thing, I told you from the beginning, Nick essentially didn't have a case. He should have pled immediately. And the reason why is that the cops went in there with strong probable cause, and when they went in, they found the coke, they found the guns, they found the girlfriend, like they found everything. And if you couldn't get the warrant bounced, you are looking at going through a trial where they're going to say guilty on all charges, and your wife is looking at a trial where they're going to say guilty on all charges. So yeah, bro is cooked. Yeah. This is it. He's going to be a convicted felon, no doubt. Nick is going to be a convicted felon. Right, he's going to be a convicted felon. That's something. How it's going to affect his law license. There's a lot going on here. There's a lot going on here. So we'll see. But let's see, because he may have pled, even though it does say he's pleading guilty, he's a felony guilty. He could have, there could be some mechanism that lets them knock it down to a misdemeanor or something like that. But this is not looking good. My attorney has told me, and I understand. So they're making sure now. Okay, so now you're not crazy. You're not under any type of duress. You now, and on top of that, you got an attorney. You got an attorney. So here we go. My attorney had told me that the prosecutor for the case against me has one, physical evidence obtained as a result of a search for seizing evidence. True, right? That's factually true. Evidence in the form of statements, oral or written, that I made to police or others regarding the crime, which he did. Remember, he had to give that interview to police, so that's also true. Evidence discovered as a result of my statements or as a result of the evidence seized in the search. Identification evidence from lineup of photographic evidence the prosecutor believes indicates I committed one or more other crimes. So this is what him and his lawyer told him, and he understands that I have the right to a pretrial hearing before the judge determines whether or not the evidence the prosecution had could legally be used against me if I went to trial in this case. That if I request this pretrial hearing, I could testify at the hearing if I wanted to, but my testimony could not be used as substantive evidence against me if I went to trial. And that's the pretrial hearing. In other words, they're saying, to determine it, you may have to testify, but we're not going to use your own words against you, because that would be unfair, right? If the government, if we're trying to figure if the government has a case, and then we have you testify, and then you can, essentially say I did it, and then they're like, oh, now we have a case because we forced them to prove our case. So it doesn't work that way. Biden parts. Here's another one to come in. Do you think the judge will force him to get a real job at the term of probation? Not letting him streaming as a job. I don't know. But that they'll determine that at the sentencing hearing, whenever sentencing is. But this is just pleading. So it's like, I'm guilty. And then you go to sentencing. Sorry about all the questions, but these are good questions. Even the questions from the chat are good. Let me continue on. All right. I'm worried about this. He has the right to a pretrial hearing. Wouldn't be used against him. Here we go. That I do not request such pretrial hearing. So he's not requesting that hearing. So in other words, they're saying you get a choice to say, judge, determine if the prosecutor has enough to take me to trial, that this evidence is enough to take me to trial. And the judge, and then you can have that hearing. Nick is saying, I don't want to have that hearing because and then he may have to testify. So he said, and then they say, well, listen, even if you testify, I'm not going to use that against you. Niggas say, I don't want that trial. Specifically, he waives his right to that trial. I do waive his right to that trial. So it's a right in Minnesota to have that trial, that pretrial hearing, and he's waiving his right to it. So, and I'm assuming this is also part of the plea agreement too, right? If you're pleading guilty, it's like, why are we going to do all this extra stuff when you're pleading guilty? So that's something he gave up. I have been told by my attorney and understand. So in other words, this is other stuff that he's saying. And again, this is making sure he knows all the consequences. He knows everything, that you're pleading guilty to crimes. This is serious. And we want to make sure you understand it fully. You're not drunk. You're not ill. Your lawyer's been telling you exactly what's going on. That's what this is signifying. I have been told by my attorney and understand that if I wish to plead not guilty, I am entitled to a trial by jury on the issue of guilt, and all jurors would have to agree. So that, in other words, this is stuff that Nick obviously knows. If I plead guilty, I will not have a trial. If I plead guilty, I will not have a trial by a jury or by a judge without a jury, that with knowledge of my right to a trial, the issue of guilt. Now I waive my right to a trial. So they make sure, like each one of those rights, they say, we want to make sure you waive your right to remain silent. We want to make sure you're waiving away that right. So they're literally saying, this is something that you know that you're going to waive, your right to a trial. And he's going to say, you get a trial, you get all this. So this is a good part. I've been told by my attorney to understand that a person who has convictions or prior convictions can be a longer prison term for this offense, but he doesn't have any prior convictions. He doesn't have to worry about that. The maximum penalty that the court can impose for this crime, taking into consideration prior convictions, is a punishment of 25 years. So they're saying the court can get you up to 25 years if you plead guilty. This is a little crazy, but now the court's not obviously not going to give him 25 years. That'd be ridiculous. But so he's looking at 25 years. So Nick is pleading, I did it, and I know you can give it 25 for it. Damn. For felony driving, and then it says sentence imprisonment not less than blank months. For the felony driving while impaired, sex offense. So they talk about sex. This doesn't apply. Intentionally aiding or inviting, counseling, conspiring other people to commit a crime. So this doesn't apply. So that's why these NAs are here, I'm assuming, because these don't apply. I have been told by my attorney and understand. Now, this is the plea part about it. This is where he saves his wife in April. So that my attorney discussed this case with one of the prosecuting attorneys, and that my attorney and the prosecuting attorney agreed that if I entered a plea of guilty, the prosecutor will do the following things. So this is the exchange. I'm pleading guilty, but this is what you do for me. Plead guilty to the amended charge of drug possession in third degree. So he's still pleading guilty to a felony, but we're going to go down one level, not second degree, but third degree. Statutory stay adjudication pursuant to Minnesota statute 5152.18. I got to look at that statute. Remaining terms of the sentence at court's discretion, and the state drop all other charges. So he's just pleading to the third degree drug possession. The other two charges are gone. So the child endangerment charge and the gun charge is gone. So he's only pleading guilty to one charge. And this is written in. State dismisses, that's the case number against Kayla Rekieta and case against April M. Holt. So Nick pleads guilty to third degree. He gets a statutory stay pursuant to blah, blah, blah. Rest of the charges are dropped, and they also have to drop the charge against his wife and girlfriend. That's it. That's it. If the court does not approve this agreement, then they go back into it. Any testimony I've given concerning the plea of guilty could not be used against me, because it would be foul for them to come to this agreement and then the judge throws it out and then they have, he pled guilty, so we're going to use it in court. They can't use. So in other words, if this all breaks down, they can't use this in court. So that's it. Exempt for then. That's essentially all she wrote. There's some other stuff here that's just really legalese, and he signs this